Mary will ask you to take the oath.
Please state your full name.
Nicholas Thomas Symonds.
Take the book in your raised hand and please read from the card.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Now, Ms. Richards will ask you the questions.
Thank you.
Minister, you were appointed Paymaster General and Minister for the Cabinet Office on the 8th of July 2024.
Thank you very much for that question. Before I answer, I wanted to take the opportunity to make a very brief opening statement. Throughout these past 10 months, it has been a solemn privilege to have the opportunity to listen to the infected blood community. And I know many people before me will have suffered unimaginably because of this scandal. And I would like to acknowledge that the government has failed you over decades. And on behalf of the state, I am sorry. I was appointed to the role of Paymaster General Minister for the Cabinet Office. It was actually on the 7th of July 2024. But my involvement in this issue began when I was given responsibility for it in opposition in September 2023. In December 2023, the opposition supported the amendment in the name of Dame Diana Johnson to the Victims and Prisoners Bill that brought forward a legal duty for a compensation scheme to be established within 3 months of the bill receiving royal assent. The then government lost the vote on the amendment. The bill progressed to the House of Lords, where it became clear that the then government did not wish to be bound by the strict 3-month timeline and sought to come to a compromise. I, as principal opposition spokesperson, refused to compromise on this, and the 3-month deadline remained in the bill. The snap general election, being called on the 22nd of May, meant the Victims and Prisoners Bill received royal assent on the 24th of May, and the 3-month period expired on the 24th of August 2024. Thus, in my first days in office, I was confronted with a statutory deadline I had myself insisted upon in opposition, and I was unequivocal that the system had to be driven throughout the summer to meet that deadline, and it was. I took on board feedback from the community through Sir Robert Francis' engagement exercise during the general election campaign, accepting 69 of his 74 recommendations. Indeed, I've made other changes, including the widening of eligibility for siblings, on hepatitis B reactivation, the scope of the Unethical Research Award, on IBCA not having to recoup monies paid in error, the position regarding the estates of affected people, and producing a user-friendly explainer. However, I did not think, given the work of Sir Jonathan Montgomery and his expert panel on tariffs, that seeking to repeat that exercise to expect different results was in the interest of victims whose compensation payments would then be subject to even further delay. I was also confronted with a situation where the money had not been allocated to the scheme by the previous government. It was imperative that I secured the money from the Treasury, and I did this with the Chancellor announcing £11.8 billion in the October budget. Payments to the infected then began by the end of 2024. I'm restless for further progress on payments, and I look forward to the chance to contribute this afternoon.
Thank you. And some of those issues we'll obviously be coming back to in more detail. And just so that that chronology of events is clear, when you took up the role on the 7th of July, and I think Wikipedia might need amending in that regard,
I think it was announced on the 8th of July.
The Victims and Prisoners Act had passed, as you've explained. The expert group had already been appointed and reported to the Cabinet Office. A scheme had been formulated by the Cabinet Office, and Sir Robert Francis had undertaken that compressed engagement exercise in June. And those all happened under the previous government before you took up your post.
That's correct.
When you became Paymaster General, or indeed when you took up your shadow role perhaps the previous autumn, what was your knowledge and understanding of the infected blood scandal?
So back to September 23, I obviously knew the broad outlines of what had happened because of the media coverage. And I was actually in the Parliament, the 2017 to 19 Parliament, which is the Parliament when the inquiry that Sir Brian led was actually brought into being. I think it was under the premiership of Theresa May. So I knew, obviously, the outlines of the scandal from that time. I'd read the journalist Caroline Wheeler's book, Death in the Blood, but in terms of my ministerial, or in that case, shadow ministerial responsibility, that was the first time there'd been any direct responsibility in that sense.
When you took up your role in July, what did you understand was wrong about the culture of government that had been experienced by the infected and affected?
So I think there's a number of issues with culture that were an issue here, and I'm sure we'll come on to proposed statutory duty of candour in due course. But in terms of government and looking back at government over the decades of this scandal, there were clearly issues with transparency, but there were also issues, frankly, with that concept of candour. And one of the pledges that I was elected on as a Labour Member of Parliament in that election was the introduction of, we call it a Hillsborough law, but obviously Hillsborough is only one of the many tragedies and state cover-ups that we're actually dealing with. And I think it was described in Sir Brian's report of last year as not so much an open conspiracy, but something that Sir Brian described as ever more pervasive, that actually what it was a culture of institutional defensiveness. Public servants putting their own personal reputations, or indeed the reputation of the organisation or institution to which they belong, above the public interest. So that was what I had in my mind. And of course, I think it was literally 2 days before the general election was called, Sir Brian, I think it was the 20th of May of last year, we'd had the report that had set that out. So the idea of lack of transparency, lack of candour was already in my mind because of my knowledge of previous scandals going back to Hillsborough and others. But what was immediately in my mind was that conception that was in Sir Brian's report from the 20th of May last year.
And is this government committed to principles of transparency, openness and candour?
Yes.
Now, the government's manifesto committed to the introduction of a statutory duty of candour. That was repeated, I think, in the response to the King's speech.
Yes.
It was repeated at the party conference. It was described by the Prime Minister as a duty owed not to the Hillsborough 97, but owed also to, amongst others, the victims of infected blood. The deadline that the government set itself for introducing that statutory duty of candour has passed. That was the Hillsborough anniversary in April, with no bill or act yet on the scene. Are you able to tell us when we're going to see that?
Well, I can't give a precise date for introduction at the moment, but what I can say is that, firstly, the government remains committed to introducing a statutory duty of candour. That is a general duty that will include criminal sanctions. That is to deal with not just the situation at Hillsborough, where clearly there was not just the changing of witness statements by South Yorkshire police officers, but also the way in which the false narrative was subsequently embedded as well. Also to deal with the situation, as I've described it, as to what happened with the infected blood scandal, which is not so much an overt conspiracy, but that pervasive culture that Sir Brian described. What the government is looking to do is to work with the families and other groups to ensure that we have a bill before Parliament that is actually tackling that culture, that is actually dealing with what went wrong in the past. Now, myself and the Lord Chancellor, Shabana Mahmood, wrote in the couple of weeks before the deadline that you mentioned of the 15th of April, to the Hillsborough families, setting out that we would be redoubling our efforts to speak to them and to work with them and to bring forward a bill that truly does seek to do all it can to prevent these kind of state cover-ups, these pervasive cultures from taking root again.
Just a couple of follow-up questions on that, if I may, before I turn more directly to issues of compensation. Want to press as to whether there's any idea of timescale, and I mention it for this reason. Your colleague, I think it's Lucy Powell, in her capacity as leader of the House of Commons, told Parliament on the 3rd of April that the government was working on the bill at pace. And everyone in this room will recognise that phrase because it's the phrase the previous government repeated about the compensation scheme. So is there any end point? Has the government set itself an end point? Anything you can tell us that gives a degree of reassurance about speed?
No, as I said in my first answer, I can't give a date for the introduction of the bill. What I can say is that the work with the Hillsborough families and indeed other groups as well. For example, I attended a day of listening only back in February to listen to many other groups, including obviously Post Office Horizon victims, those who are victims of Grenfell Tower. This is a bill of wide application. But what we will continue to do, it is a landmark bill for the government, and we will continue that work to get it right, to make sure that it is not a bill that has unintended consequences, that it is a bill that is actually tackling those things that we and the families of these scandals actually want to do our best to prevent from happening in the future. So I'm sorry I can't give a definition of at pace or a precise date, but the work is most certainly ongoing.
Are you able to give an assurance that whatever the government puts forward will encompass civil servants and the actions of central government?
Yes.
I want to then touch next on the position of the previous government. Now, I'm going to pick up the question of why certain decisions were made with Mr. Quinault tomorrow,
yes,
because he was the Director General at the relevant time within the Cabinet Office. You were not in post until July of last year. But just as it were, to give a basis before we move forward, the previous government said that it was required to wait for the final report of this inquiry before it could progress the question of compensation. Given that the government's detailed plans were revealed on the 21st of May, the day after the very lengthy report was published, do you agree that the previous government clearly did not need the final report in order to work out a compensation scheme?
No, they didn't, and that was a point that I was making as opposition spokesperson. I was urging from the opposition benches it to be done more quickly. There was obviously an interim report of Sir Brian's that was at an earlier stage that had actually spoken about starting this work at an earlier point, and that is what I believe the previous government should have done.
And it's been suggested to the inquiry by many within the infected community that they were misled by the previous government. Do you agree?
I can completely understand why people felt like that. I also felt, and I'm choosing my words carefully because obviously there's a particular issue, misleading the House of Commons is something that has particular consequences. But in terms of the public being misled as to the speed with which the previous government was setting up the scheme, I would agree.
Yes, and I understand, and I wasn't asking you about the question of misleading Parliament for the reason that attracts something called parliamentary privilege, and there are legal issues there. I want to come next to the extent of the involvement of infected and affected people in the design and development of the scheme. And that requires me to start before you came into office, but then come to the period since you've been in office. And I'm doing this in part so that there is absolute clarity for those listening, because you will appreciate the events of the last year or more have been very difficult for many people to follow. So first of all, it's correct, isn't it, that there was no involvement of infected and affected people in the previous government's decision to establish the expert group?
Again, I'm commenting on what I've heard about it. I was obviously not directly a part of that process, so in terms of whether there was communication, letters between the community and then civil servants, that's obviously a question best put to Mr. Quinault. But it's certainly the case that the victims felt that way.
Well, what I'll do then is I'm going to put this as a series of statements from me and then build upon those rather than asking you, and then I can pick it up with Mr. Quinault. So I'm going to suggest, and the inquiry has had ample evidence to demonstrate this, that there was no involvement of infected and affected people in the decision of the previous government to establish the expert group. There was no involvement of them in decision-making regarding the remit of that group or its terms of reference. There was no involvement of them in relation to the membership of that group, and they weren't even allowed to know who was on it other than Sir Jonathan Montgomery. And there was no consultation with them regarding the scheme which was put together by the previous government. And then we get to the engagement process undertaken by Sir Robert Francis. Now that's the point at which you come in, Minister, because Sir Robert's report, which is dated, I think, the 12th of July, effectively comes across your desk.
That's right.
Within a few days of you taking office. Now, I think it's right that beyond that engagement exercise undertaken by Sir Robert, there was no consultation on the draft regulations, on the scheme itself as envisaged by the 2024 regulations. No doubt because of that 3-month time limit. Is that right?
There was no formal consultation because precisely, and although it was a 3-month time limit, that is true, obviously a significant number of weeks had already passed of that 3 months by the time that I got into office on Sunday the 7th of July. So what I actually had was a period of 6-7 weeks to the 24th of August, which was the statutory deadline. But it's true to say there was no formal consultation ordered then.
Now, understanding as we do those time constraints, it's right, isn't it also, that there has been no consultation on the scheme as set out in the 2025 regulations?
No formal consultation, but just to make this point clear, it is because of the need to push forward as quickly as possible. And with the consultation, let me just take that earlier period. I come into office, I have at that point a scheme that has no money allocated to it. So it was obviously an absolute priority of mine to secure that money from the Treasury, because without the money there is no scheme at all. So that was obviously a huge thing in those early days. Second, I wanted to drive the system to produce that first set of regulations by the 24th of August, because I thought that it was absolutely critical, and I felt that if that deadline was to be missed, we just have yet more drift, yet more problems of delay. So I felt that they were the absolutely fundamental things that had to be done in that period to ensure that not just we met the deadline, but obviously you had then the legal basis of the compensation scheme, at least for the core route having been established.
And that I understand, Minister. So I understand why you get to late August 2024 with the regulations being laid, absolutely because of that statutory deadline, and you've come into post halfway through that period, or roughly. But my question is about where we are now, so, 31st of March, the 2025 regulations. I said to you no consultation. There was a limited consultation on the Unethical Research Award. Put that to one side. On the rest of it, I know there have been meetings, but there's been no real consultation.
Well, there's been no formal consultation, but let me just take the point about hearing the voice of victims, because firstly, with the earlier period, I obviously had on my desk waiting the product, the report of not just an exercise of consultation by Sir Robert Francis, but a set of 75 recommendations. So it wasn't just there'd been consultation, there were then a series of recommendations that, so I felt that coming into office, in a sense, the voice of the victims was on my desk in terms of these changes that were required, and I accepted 69 of the 75 recommendations to the scheme. In terms of then moving forward and hearing the voice of victims in the design of the scheme, I then have a second set of regulations that are needed. Again, I pushed the system to get a deadline of saying I want these onto the statute book by 31st of March 2025. Now, that autumn of the last autumn of 2024, I obviously signed off some interim payments to the estates of the deceased infected. I wanted IBCA, obviously, to make the first payments by, to be established, make the first payments by the end of the year. There was also the end-of-year deadline for the interim update on Sir Brian's wider recommendations. Now, prior to the first set of regulations being announced, I met 7, I think it was, representative bodies, but that was more, a courtesy of the announcement the next day. I felt that the voice of victims was already on my desk from the Sir Robert Francis consultation. That autumn, then, I was always concerned of not holding meetings for the sake of it, not just holding meetings to tick a box, when what was going to be happening was there'd clearly be government work in the autumn, but, the decisions would be working their way up to me as a minister, later in the year into the early part of 2025. So I obviously held meetings. This is me personally. That was at the start of December, at the meetings at the end of January, and I most recently held another set at the start of April. But also alongside that autumn, I was obviously hearing from members of Parliament on behalf of victims in their constituencies, whether we had a general debate. I made 3 statements. I was answering numerous written and oral questions as well. But also, letters. I mean, I'm sure you can imagine, I've got quite rightly a lot of correspondence, and also, of course, people telephoning civil servants at the Cabinet Office. So I felt very strongly in terms of decisions that I was making that the voice of victims is coming through very, very strongly in those different ways.
Whatever the understanding back in August of last year, over the subsequent months, it must have become obvious to you, and if not, will have been made evident through the statements that this inquiry has obtained and published, that there is deep and profound unhappiness with significant aspects of the structure and design of the scheme. What, if anything, does this government intend to do about that?
So, as I indicated in my opening statement, there are some aspects of the scheme that have been changed. For example, there's the issue of sibling eligibility, and the original design of the scheme had that exclusion, essentially, of adult siblings, which has been changed, and about which Sir Brian wrote to me in terms of clarifying intentions from the original report. For example, in the Sir Robert Francis consultation, one of the major changes I made was the continuation of the support schemes, which is another example, around, for example, the Unethical Research Award and its scope. But I should also just be very open here as well. It is abundantly clear to me that there was unhappiness with the tariffs and the differential tariffs that are in Sir Jonathan Montgomery's report. But the issue I faced some months later was again that dilemma you are constantly facing between, on the one hand, pushing forward the payments and the speed, or doing things that are going to create an even greater delay. Now, when I came into office, I looked, of course, at Sir Jonathan Montgomery's tariff scheme very, very carefully. It wasn't something that I had ordered as a minister, but it was what I had inherited. And of course, you could, as a minister, have another group. You could do it in a different way, set it up perhaps in a different way. But number one, I think it's highly unlikely there wouldn't be some form of differentiated tariffs in another version of the scheme. But secondly, to try to go back and disturb that, my judgment was that would have created an even greater delay than the one we face already. And that has been the dilemma throughout. I have made, as I indicated in my opening, a number of changes to the scheme, clearly because of the voice of victims being heard. But it is also the case there are changes this government hasn't made, and it is because of this dilemma constantly being faced of not wanting to create even greater problems, even further delay. And you know, I would also point on that. The reason the 3-month deadline even existed is because when I was the principal opposition spokesperson, I refused to compromise on it. Now, I had no idea at that time that there was going to be, neither did any of us, there was going to be a general election called on the 24th of May, but it did put a deadline into the system that otherwise wouldn't have been there.
Isn't the answer to the dilemma you describe, given where things are now, that you allow, indeed encourage, IBCA to continue processing claims under the current scheme so that there's no suspension of the scheme, thereby avoiding further delay. But in parallel, and this wouldn't interrupt the work of IBCA at all, because as we know, all the tariffs are set by the government. In parallel, the government undertakes a consultation process, a formal consultation process, with those infected and affected on the key aspects of the scheme and its design that have caused so much unhappiness, anger and distress. And then the product of that can then be fed back into, so all those who will have had their claims assessed under the existing scheme, if they're entitled to more, then there can be a supplementary payment to them. But it's not a binary decision, is it, Minister?
Well, I think it depends very much on which aspects of the scheme we are now going to consult on. Because at the moment, the situation is that the scheme, in a legal sense, is on the statute book. We met the 31st of March deadline. Now, of course, there are things like, take, for example, the scope of the Unethical Research Award. Now, that is something that I, or indeed any other minister, could go back and make some changes, could make changes. They could add, for example, a particular centre if further evidence came to light. But if it is seeking to disturb the whole basis of the scheme in the sense that we require more legislation to go through Parliament, the period, you know, as I've discovered myself as a minister, I've twice pushed the system very hard to get those regulations onto the statute book in the 10 months that I've been in office. What would concern me about the scenario that's being mentioned is that it would put, I appreciate the point that's being made about parallel lines, but I would worry very, very much that something that made fundamental changes would cause that undue delay if it required going back to change the legal basis of the scheme.
So is the answer to my question, what, if anything, does this government propose to do in relation to the various respects in which deep unhappiness and anger has been expressed about key aspects of the design of the scheme? The answer to that question is that the government doesn't intend to do anything.
No, the role that I see now for myself as minister going forward is twofold. I think firstly, and in relation to IBCA is operationally independent. It has a framework document that we follow. But I still see my role in two senses. Firstly, to hold IBCA to account on the speed of payments, because whilst there is that operational independence, I will nonetheless, quite rightly, be the minister held to account by Parliament for the speed of the payments, and quite rightly, that's how our democracy works. But I think that is important, that I am questioning, pushing, asking, pressing forward on the speed of payments. And To make, and I'll come to the second point in a moment, but on this point, and I appreciate the inquiry here will be hearing from David Foley and Robert Francis tomorrow, so I'm not seeking to anticipate their evidence, but what I've always been reassured of is the test and learn approach, and what the test and learn approach means is there is that smaller number of cases. There was the objective of 250 offers by the 31st of March. And what going through those cases would mean is there would then be an opportunity to speed up the payments. And what I mean by that is if you looked at a graph of time and number of offers made, let's call it offers, that there will be a very steep part of that curve. That is the purpose of using the test and learn approach. So what I will be pushing forward very strongly now is when we get to that steeper curve on that graph of a lot more offers being made. And the second point is, whilst of course recognising IBCA's operational independence, to also be on hand to provide what is required. If they come back, for example, they need more people actually working on these cases. If they come back, there are issues of procurement, for example. So I really do see the role going forward. And I'm not, as I say, ruling out changes, some changes. I've talked about unethical research, for example. But what I wouldn't wish to do is make changes that cause further undue delay. But I certainly see the role now as doing our very best to push forward IBCA's speed of payments whilst respecting IBCA's operational independence.
I'm going to ask the question again, Minister, because what you've answered anticipates later questions I have about the issue of delay, and you're absolutely right to identify that as a very important issue. But my question is about the fundamental unhappiness there is with key parts of the scheme itself. I infer from your answer that this government currently, leaving aside the possibility of perhaps a change to the Unethical Research Award, this government currently has no plans to consult on and consider making changes to that architecture of the scheme. Is there a yes or no answer to that?
The current position is we are not proposing a further consultation on the fundamental design of the scheme for the reason that disturbing its fundamental design, we believe, would lead to the need for further laws to be going through Parliament that would simply create even greater delay. Now, I'm not ruling out, I've made the unethical research award example, changes you could make without causing delay and without causing that sort of fundamental difference that would lead to a delay in payment. So the answer to the question is that what we're not prepared to do are to do things that would cause even further delay going forward.
Has it occurred to you and your officials that there are changes that could be made that would meet the concerns of some, which were voiced very clearly this morning, that might speed the process up ultimately? That you will be aware of the profound unhappiness there is about the tariffs in relation to hepatitis awards.
Yes.
And you will be aware that the scheme as currently structured involves people producing piece of evidence after piece of evidence after piece of evidence to show not just that they were infected with hepatitis C in around 1984, but to show through medical evidence the different stages at which they went through the different levels, in circumstances where many of them will never have that evidence, either because they were never under the care of a hepatologist or because their medical records have been lost or destroyed. So simplifying the tariffs would actually speed up the process of assessing the claims and making payments. Has that been considered by the Cabinet Office?
We've considered a range of things. I've considered, let's just take that issue of whether you, as a minister, start intervening and changing particular tariff bands or simplifications. There's 2 points there. On the first point, I don't think it would be for me arbitrarily, and I don't think it would be rational, I don't think it would be sensible to victims as a non-expert minister in this field to start disturbing different aspects of the tariffs. The alternative to that, which is something I did absolutely consider when I came into office, was whether or not something could be done that was subsequent to St Jonathan Montgomery's original tariff design, whether you could ask him or indeed somebody else to produce something different. And the government's judgment was that if you did that, I still think you would end up with differentiated tariffs. I don't think you would end up in a situation where every tariff would be the same. But the second point is I do think that that would lead to undue delay. To your second, and I think really important point around level of evidence, that is something that's been a deep concern to me throughout the process. And I think that is for 2 reasons. I think firstly because so many of these things happened so long ago. But secondly, because Sir Brian's report identified deliberate document destruction. So it isn't just sometimes that documents weren't available. And I've always emphasised the need for an enabling culture at IBCA, so that it isn't just that evidence is demanded from people, but more that there is a pointing towards where such evidence can be obtained. And, I visited IBCA only a few months ago, and again, Sir Robert Francis and David Fuller will, I'm sure, talk about the culture they're seeking to embed. But I was struck by speaking to different caseworkers of the need for that more compassionate enabling culture.
Can we just examine, I hope shortly, because I don't think this is controversial, the extent to which the scheme that we have differs from the scheme recommended by this inquiry? And that's a major concern and theme from this morning's evidence. So the inquiry's recommendation was a scheme, and I'm using that word deliberately, yes, that must be completely independent of government and must be seen to be. Now, I'm going to suggest to you that the scheme as established is the opposite of completely independent from government for 2 essential reasons. The first is the tariffs, the amounts people actually get, and the criteria that they have to satisfy to get them, have been determined solely by government, not by the body set up to administer the scheme. That's right, isn't it?
It is correct. The tariffs were determined, they were advised to government by Sir Jonathan Montgomery, that is true.
And that's not what this inquiry recommended.
No, and just on the issue of that just for a moment, again, that is something that I inherited coming into office and made a judgment about in terms of whether I went back and redid the exercise. And obviously
could you
the
just
need...
bear with me one moment, please. I hope everyone will remember what I said at the start of today, that every witness must be allowed to give evidence to the best of their ability. And whatever their views, I would hope that you would respect the answers which they may be given. I don't expect to avoid the intake of breath if there is one, but please bear that in mind, would you? I'm sorry. Would you like to start again?
Thank you, Sir Brian. But yeah, just to emphasise that was the position that was there when I took office, and I had to make a judgment as to whether or not going back to redo that was going to cause undue delay or not, and our judgment was that it would have done.
You've referred to the role of the expert group, and it would seem apparent, both from your answers but from everything else we've seen, that expert group has played a central role in the shape of the scheme and the nature of the tariffs that we have. Is that right?
Yes.
But the way in which that expert group operated, and again, I absolutely accept it's commissioned under the predecessor government and your predecessor, again, that was completely contrary to this inquiry's recommendations as to how there should be a clinical group and a legal group, and fundamentally the engagement of the infected and affected in that process. So that didn't happen, did it? Not your decision, I know, but that didn't happen, and that's contrary to this inquiry's recommendations.
That's correct.
In the interests of transparency, are you able now, will you, make available publicly the documents that record the decision-making process of the government, previous and current, in determining those tariffs, in devising the IBCA structure, and in drafting the regulations, and any documents which record this government's decision essentially not to go back and revisit that substantively?
I'm certainly willing. You will understand, I'm sure, that there are certain laws around the conduct of government, how government operates, but I'm perfectly willing to take back that suggestion, subject to those other laws, which I know you'll be very aware of, to see about whether I can push further transparency. I'm more than happy to do that. And in respect of the expert group, I was given a series of decisions to take last summer about openness regarding their decisions. I've always pushed towards transparency, but I'm sure you will understand there are particular rules and laws about the conduct of government. I couldn't just simply offer that, but I can certainly go back and look at whether I can push at the transparency on it.
Well, and this inquiry can certainly assist by providing a description of documents, and obviously this inquiry has the power to compel their provision, but my request was for voluntary making that available. Can I just touch on a topic of IBCA's lack of autonomy, its lack of discretion under the scheme? So again, I think this is uncontroversial, but not necessarily well understood. IBCA itself has no power to decide what people should be compensated for, or how rare cases should be compensated, or how much compensation people should receive. Its role is limited to an assessment of applying the rules that have been determined by the government, effectively, to an individual circumstances.
Applying the scheme to the individual circumstance.
And so IBCA has been set up effectively to have no discretion over the central issue of how to approach the payment of compensation.
So I accept that it is IBCA operating within the scheme or within its rules. That is entirely correct. But also just to come back to this fundamental point, because there is again, a balance to be struck on the scheme, because as you mentioned in your opening question on this particular issue about a compensation scheme and its complete independence of government, but it's a balance between the trusteeship of the money that is going into the scheme. It's I stand corrected, but to be correct, I think it is quite right. The largest compensation scheme in British history has got an £11.8 billion allocation, and clearly the government has to account, as I have to account as a minister to Parliament, for that money and the spending of that amount of money, as you would fully expect. But you are right then to say that within the scheme as designed, it is then for IBCA to apply the rules as it sees fit to individual cases.
Now, Mr. Quinault, in his statement, and for anyone's reference, it's a paragraph 170 of his second statement, has suggested it would be unlawful for IBCA to be granted any wide discretion by the regulations. And I mean, we can put up on screen if necessary, but there's a Cabinet Office fact sheet from January of this year which says this, and I'll just read it out. Because of the way the Victims and Prisoners Act works, the scheme has to be set out in law. This law has to provide IBCA with all of the precise details it needs to assess claims and make payments. Now, I'm not going to debate with you, even I know you're a barrister, Minister, but I'm not going to debate with you the correct construction of the 2024 Act. I think I've detected the statutory provision that Mr. Quinault may be referring to, but I certainly can see scope for an alternative view. Again, in the interest of transparency, but also to allow others, including this inquiry, to, if appropriate, advance an alternative view. Are you able to agree to disclose the legal or other advice on which the Cabinet Office has formed the view set out in the fact sheet?
Again, because, as you will know, government legal advice is subject to a particular convention about confidentiality. I would, again, I note the request, and I'm perfectly willing to look at whether that is possible, but you will be aware of the convention that all governments have adhered to, save in very exceptional circumstances about legal advice.
I'm a great fan of considering conventions and then departing from them, Minister.
I'm sure you are.
We've touched on the question of delay and the timescales. And I just want to put the figures out, the most up-to-date figures out into the public domain. We'll obviously be hearing more on this tomorrow morning and ask you a couple of questions in relation to that. So, nearly a year after the inquiry's report, over 2 years since the inquiry's report on compensation, over 3 years since Sir Robert Francis delivered his compensation framework study to the government, according to the figures published, I think, yesterday, 106 people have been paid compensation. Now, in fairness, there's an additional, I think, 54 who've received offers, and the total figure for those who've started the claim, and there's been a sharp increase in the last 10 days or so, is 432. But that's a profoundly unsatisfactory state of affairs, isn't it?
It absolutely is, and I'm never going to think this is satisfactory until everybody has received the compensation they're due.
Now, we've got the timescales that IBCA are working to set out in the framework agreement with the Cabinet Office, and Mr. Foley's referred to them in his statement. And again, so that everyone can follow, he says what they're working to is to pay the first infected person by the end of 2024, obviously that has happened, to pay the first affected person by the end of 2025, to pay the bulk of infected persons by the end of 2027, that's 2.5 years from now, and to pay the bulk of affected persons by the end of 2029, that's 4.5 years from now. And sorry, just before you respond, Minister, I should add, he says IBCA's working to try and deliver ahead of those dates.
I do not regard those as targets. I regard those as backstops. The objective should be absolutely to pay as soon as possible.
It's a reality, though, isn't it, that people, both infected and affected, are going to die without ever receiving compensation?
Yes.
Now, may I just ask this? I think it's paragraph 52, if I remember correctly, from Mr. Foley's statement, where he deals with these dates and timescales. He says those are the timescales agreed with the Cabinet Office. The expression "the bulk of" means not all. So does it follow that the timescales agreed with the Cabinet Office, albeit that they would try to go faster, mean that some people who are affected will not be paid until 2030, if then?
Well, the reason for that word bulk is because there may well be people who hadn't come forward, who hadn't identified themselves. So that's why that phrase, and I'm sure, Sir Brian, that could be put as well to witnesses tomorrow, but that is my understanding, that there still remains a possibility. I take, for example, the point about infected people being paid, that there may still be people who come forward, and I wouldn't want the door to be closed on those people. But the point I would make around the infected and the living infected, when I spoke earlier about the idea of the graph of time elapsed and number of people to whom offers have been made, I would fully expect that group to be a real priority going forward for precisely the reason that you are putting to me, that people are dying every few days.
And people affected.
Yes.
Parents who watched
Yes.
their kids die of AIDS.
Absolutely, yes. Absolutely.
Widows and widowers who
You're
nurse
absolutely
their
right.
partners. You've said one of your goals is to keep the momentum on to push IBCA. What can you tell us about any practical, concrete steps being taken by the government, by the Cabinet Office, to try and speed the process up?
So I obviously have discussions, I'm sure David Foley and Sir Rob Francis will be able to say to you tomorrow, but what I am saying to IBCA is, what is it that we have to do to speed this process? And one thing, for example, is what I would describe as appetite for risk, taking more risks, that in another government compensation scheme somewhere else, there'd obviously be things around fraud that very appropriately governments do bear in mind when they're making out huge payments. Here, particularly, for example, with the living infected, who are registered, we absolutely know who they are. And I've been saying, can we take, less of a, can we have more appetite for risk than would ordinarily be the case to prioritise this? I'm also questioning, what is it in terms of procurement, for example, that we can do to speed this up? What can we do in terms of additional people, additional caseworkers? What are the steps? And these are questions that I am asking of IBCA, and I stand ready to support going forward in terms of what's required.
In relation to that first question you posed about appetite for risk, you said you've asked those questions of IBCA. What answer has IBCA given you?
IBCA will obviously be able to speak for themselves tomorrow, but their position, as I understand it, is that they will be in a position to take that greater risk. We are, I'm currently, as I talk here to you today, going through precisely what that is going to look like, but that's something we're driving at the moment.
Is there a commitment from this government to provide IBCA with all reasonable resources necessary to make payments as soon as possible?
Yes.
Is there a restriction on the amount of money available to IBCA each year? The government's budget allocation that you've referred to, as I understand it, the 11.8 billion is over the spending review period. I understand that questions have been asked by individuals, I think certainly of IBCA, to which the answer has not been as unequivocally clear as people might like. So is there any restriction? Is there any cap on what IBCA can pay out in compensation on an annual basis?
No.
Before we move off from the question of delay, I want to ask what, if any, consideration has been given by the government to ameliorating the effect of delay, given that it will be a number of years before some people receive that compensation, either through introducing an uplift to the awards on an annual basis or through the payment of interest. And just before I ask you to answer, the idea of regular uplifts to awards is not an unknown, unprecedented one. It happens with a range of different categories of awards across the law. So what's the answer to that, please?
So with regard to your second point and the accrual of interest in terms of the point at which the payment is made, we've obviously given consideration to that, but the view we've taken is that this is a broad tariff-based scheme, and we have to look at fairness across the totality of the scheme. So, for example, if you looked at past care awards and you had a claim before a civil court, you would obviously take, the way it's calculated before civil courts, you would have the rate, the particular commercial rate. It's usually discounted for care being offered. It's called in law gratuitous care, but obviously it's care being provided by someone free of charge. Now, before a civil court, if you had individual legal claims going on here, you would look at the period the care was provided, take the rates, then update them. Now, this scheme actually takes rates from the early 2020s, which is obviously a lot more generous than it would be before the civil courts. Now, it is the case on the other side that there is no provision for interest to be paid across the piece if, for example, someone is paid at a later stage. But it's looking at the totality of the scheme in terms of its fairness, which is why that hasn't been done.
And what about uplifts?
The same view is taken on, uplifts, and I appreciate the point you're making in terms of uplifts. You could do it in a broader way, but the view has been taken that it is about the totality of the scheme, and there are some parts of the scheme that are more generous than would be the case if there were individual legal cases before the civil courts. So it's taking a broad view, but also a sense that this is a broad-based tariff scheme. It isn't going to have the precision of thousands of individual cases before the civil court. So inevitably, there are some things in the scheme that are taken broadly, and this issue is one of them.
And then the position of affected individuals' estates.
Yes.
The current position, and you would no doubt want to point out that this reflects what the inquiry itself had said, is that if an affected person dies, their claim dies with them unless they've got to the stage of they've formally accepted the compensation offer and die before receiving it. Now, given what is now known, which wasn't, I think, previously anticipated, that it's going to be a number of years before probably many affected people would have their claims assessed, will the government consider, or has the government considered, changing that, either to allow the affected person's claim to pass to their estate, or at least to move to a system where the claims of the affected person can be registered with the scheme, and if they then die, their claim passes to the estate?
So I did consider a number of different options of what to do with the affected estates, because again, it was something coming through very strongly there was concern about, including, point of registration, which you've just mentioned. Sir Brian's report obviously was stating that to allow affected estate claims would be to draw the circle too widely, so that's the starting point. What I then looked at is where, to draw the line, because that is what has to happen. And you're entirely right to say that where it was drawn was the point at which there'd been an offer and an acceptance. So if there'd been an acceptance and the affected person were then sadly to pass away after it, then that is then a debt to the affected person's estate. With regard to the point where when affected people are going to be paid, the government is the position that we would expect affected people to start being paid by the end of this calendar year.
There's something terribly arbitrary, isn't there, about the idea that if a person happens to die, and many are going to die, at that point where they've accepted the offer, but before the money has actually been paid into their bank account. You could have someone who's gone through the entirety of the application process, has had their claim assessed, has said verbally, yes, that all sounds great, I will take that, thank you at last, and they die before the form is emailed to their recognised legal representative for them to sign. That doesn't feel fair?
It's an attempt to be fair, but I think to your broader point, I think where you draw the line is, to a certain extent, always going to be something that is arbitrary. It was trying to be, that particular decision was trying to be fair to Sir Brian's recommendation about drawing the circle too widely to include all affected estates. but seeking to find a point. But you're entirely correct. You could put the point in other places. You could conceivably not include affected estates at all either on the other side of the ledger. But I think between all of them being included, none of them being included, I think where you draw the line is always, to a certain extent, unfortunately going to be arbitrary.
In terms of dates and cut-off dates, the 31st of March of this year is a date that's assumed particular significance.
Yes.
It has a number of consequences, but the particular one I want to ask you about is this. The regulations provide that if an infected person dies after the 31st of March, their widow or widower will not be entitled to the continuation of the support scheme payments that these families may have depended on for years, and which they had previously understood to be for life. So somebody who dies on the 30th of March, their widow or widower will continue to get those payments. Someone who dies on the 2nd of April, their widow or widower will not. Now, it's no answer, is it, to say, well, you'll finally get compensation when your claim is assessed in 2029, because there are going to be people in profound financial difficulty, anxiety, distress, because those support payments have been cut off as at that date. Will the government look at that again?
Well, certainly the point about the gap, the point the gap suggests is obviously an issue of concern. But let me just explain that the point of the date is that within the scheme, you do need past loss and you need future loss, and there does need to be a date that is the cut-off between those things for the integrity of the scheme. But to the broader point that if it was a consequence and there are people who are in difficulty for the reason that you suggest, then obviously that is something that we'd be willing to go back and look at.
You'll be aware from the meetings you've attended and from what you've read and what has been shown to you that there's considerable anger and distress about the scheme amongst the children, siblings and parents of people who were infected, many of whom watched their loved one die in the most horrific circumstances. Because of the limited and fixed redress which the scheme offers them. And I hope, Minister, you've had an opportunity to look at a document we've called the presentation, but which summarises the evidence.
Yes.
And you'll know there is some very, very powerful evidence from a mother whose child died, from a child whose parent died, from siblings whose brothers or sisters died. And I just want to, before I ask you about that, I'm just going to quote to you from an email that the inquiry received in the last few days. This was from a sibling. We feel forgotten. Our lives were destroyed by this scandal, losing our siblings and parents, and we see no hope of ever seeing justice. We have received no compensation, not an interim payment, even though we've suffered immeasurable loss. Our life paths have been turned upside down, which is not reflected in our treatment. Now, one solution to that could be to create a new supplementary route for the affected. So for people who can show that above and beyond the immeasurable grief and distress of losing a loved one, that they themselves suffered mental illness, or they themselves suffered impairment to their education and their employment, or they themselves lost the home that was over their heads because their parent could no longer get life insurance for a mortgage, whatever it might be. Will the government consider creating a supplementary route for the affected?
Of course, I'd be willing to look at something like that within the context of where we are, provided. And my test for this is always the same in terms of the decisions I've faced as a minister since last July, and that is that I don't do things that will cause even greater delay for justice. That is always the test that I place on these matters. But In terms of the description you've just given, I've read not just evidence in preparation for the hearing today, but I've heard extraordinarily powerful testimony from affected people who lost loved ones whose lives have been completely and utterly turned upside down and devastated by what has happened. I think anybody could be but moved by reading what's happened to people.
So do I understand from your evidence that possibility of creating a supplementary route for the affected is something that you will go away and consider?
I am more than happy to go and consider it, subject, as I say, to the test of not wanting to create even more delay than we currently have.
And I'll just leave you with this thought before I move to my next topic. I would suggest it is implausible to think that that would create further delay, given where we are with affected claims.
Fine.
I'm going to deal now with a couple of issues, important issues about the regulations themselves. The first is the question of people who were infected with HIV prior to the 1st of January 1982. And the second is the question of what I'm going to call the special category mechanism or equivalent. So if we start with the position of those infected with HIV before the 1st of January 82, Lawrence, could we have on the screen, please, DHOL 603. Now, this is a recent email from an IBCA claims manager to an individual making an application through the scheme and to his recognised legal representative. And I'm just going to pick up, first of all, the second paragraph says the HIV liability window under the scheme begins on the 1st of January 82, even though there's evidence that some individuals may have contracted HIV from blood or blood products prior to this date. This cut-off is not a reflection of whether infections happened before 1982. We fully acknowledge that they did. Rather, it reflects the point at which, based on current legal advice, it is considered that the UK government and health authorities should reasonably have foreseen the risk of HIV transmission through blood and blood products and taken precautionary action. And then if we skip over the next paragraph, which provides more detail of that, and then it says, the legal test for liability focuses on what the government knew or ought to have known, and whether it failed to act on that knowledge in a way that could have prevented harm. Therefore, infections that occurred before the 1st of January 82 fall outside the liability window because, based on current legal advice, it is not accepted that the risk was reasonably foreseeable by UK authorities prior to that date, nor that they were under a legal duty to act differently. And then the last sentence of this email refers to the legal framework set by the regulations. And I think that may be a reference to, and I'm not suggesting we put it on screen, Regulation 3 of the 2025 regulations. Now, I'm sure this is a position that's not been formulated by the individual claims manager, and the reference to legal advice and the position here set out, what's said to be the position of the UK government, I'm taking it, but please correct me if I'm wrong, that this reflects the view of the Cabinet Office. Is that correct?
Yes.
So, a person infected with HIV from infected blood or infected blood products receives nothing for that infection.
So you mean if it falls outside the
liability? If they were infected,
falls outside the liability window.
If they were infected before the 1st of January 1982.
That is the consequence of that.
So a boy at Trelaws, infected with HIV because he was experimented on without consent or knowledge, would not be eligible.
Well, no, but just to finish the sentence. But my understanding of this, and I would, I think putting this to Mr. Quinault is important to in terms of the details. Yes. But the point, I didn't finish the first sentence. That is the liability window, where if you show the infection in that window and in the date, then there's an automaticity to it. But my understanding is if there was an infection before that date, the automaticity isn't there, but there's greater evidence requirements in terms of showing in
Well,
that period.
that's not what this says. So, and I'm
No, and that's why I answered in the way that I did, because that's why I said that is the consequence of what was being read, because it is the liability point. But just to take that, if he, on your point, because I understand precisely the point you're putting to me, and I'd say to the inquiry today, I'm more than happy to take that point away, because I understand exactly what you're referring to.
Well, and I'm grateful. And if I can just add to help, I hope, with your consideration of the issue. First of all, I am certainly aware, leaving aside the case that this was concerned with, of a category of cases to which this might apply. So the mild haemophiliac, treated in December 1981 and infected, not then treated at any point because they're a mild haemophiliac during that window, would fall outside the scheme and be wholly ineligible on this approach.
I am more than happy to go away and look at that situation. I can say today I'm willing to.
I'm grateful. And can I then just add this for that additional consideration? There's a fundamental flaw, I would suggest to you, in the thinking that so far has informed this, which is the idea that what matters is when the government knew about the risk of HIV.
Yeah, I understand that, and that is the basis of what the liability window is talking about here. But I understand perfectly what you're highlighting to me. My undertaking to you is I'm more than happy to go back and look at that.
I'm very grateful. So I think I'm at 3:45. Is that right? I can't actually read the clock in the distance with my terrible eyesight. I've got probably another 20 minutes, half an hour of my own questions, and then obviously we need to afford core participants the opportunity. So we may, I think, have to take 2 breaks this afternoon and take one now because of the stenographers.
Well, let me just ask you, Minister, what you would prefer to do. I suspect, given the degree of attention there is in the hall, that most people here might be happy to continue, if you were, for 20 minutes or so, and then you could field questions such as may arise from the evidence that has been given during the break, which will then follow. It means having one break later, perhaps 5 or 10 minutes longer than it might otherwise be, but only having the one break. Or you could have a break now, come back 20 minutes, have another break.
Well, if people here are content, I'm happy to continue now and have the one break, if that's okay with people here. Yeah.
Well, I think that's very kind of you, and I see that people are nodding. So shall we continue?
Yes, I've just asked that a check is made with the stenographers. Okay. I'll see how I get on, but as you know, Minister, barristers are absolutely terrible with their time estimates.
Well,
if it's 30 minutes, I'm told it's too long for the stenographers. So
no pressure, Ms. Richards.
Well, I'm not going to rush the next topic because I know it's important. It's the special category mechanism and its equivalents, and I'm just going to say SCM because it's quicker. So, there were a number of documents potentially to look at in relation to this, but I'm going to start, if I may, by putting some general points to you, because we may not need to go to all the documents if what I suggest is agreed. The banding that was put forward in May of last year, so before you took up your office, didn't include anything in relation to the special category mechanism or equivalent. And that's right, isn't it?
Yes.
And it was then identified by Sir Robert Francis in his report, which then came across your desk, as an omission. And I'm going to paraphrase what he said and see whether you accept this is accurate, and if not, we'll put it on the screen. So for anyone following, the reference is RLIT 302466, page 31. So in his report, Sir Robert set out to you his understanding from the June engagement that the expert group had gone away and looked at this and intended to advise that there should be an award reflecting the SCM criteria. And Sir Robert recommended that the advice of the expert group in that regard be followed.
Yes, without seeing it on screen,
I'll show you then what the expert group said, because I do think this is important. So it's RLIT 302474, please, Lawrence. If we go to the bottom of page 7, first of all. Yes, so we can see, thank you, it says, following the engagement events, we reflected on the feedback that insufficient recognition was given to the impact that some victims experienced. And then, so a number of additional categories were set out, and the penultimate category on that, so the penultimate bullet point on that page, other hepatitis C associated extrahepatic disorders resulting in long-term severe disability, including those on current support scheme enhanced payments.
That's correct, yes.
That's
yes,
the SCM or equivalent.
Yes.
And if we go to bottom of page 30, we can see here set out, and this is all part of the expert report, we can see they've listed, bottom half of the page, effectively what the criteria were under the 4 national schemes, and recommended that that effectively be introduced as part of the new scheme.
Yes, and I'm sure we can continue, but obviously in terms of some of the detail, I'm sure you'd want to put to Mr. Quinault on some of the bits here, but yes.
I will be returning to the
I'm
topic,
sure,
but
yes.
I'm trying to do this in broad stages.
Yes.
And so if we then go to what the government said, so your government, at WITN 776-0006, this is the government update on the 16th of August, and if we turn to page 6, it's made clear there in the second paragraph under the heading Additional Compensation Routes and Payments, following the recommendations of Sir Robert and advice from the expert group, the scheme will now include a health impact supplementary route to compensation. This will include impacts currently recognised under the special category mechanism or equivalent UK-wide bans. So that was the government's decision, and in fact, and if we need to show you, go to the document, we can. When you published the compensation scheme summary on the 23rd of August, that also encompassed hepatitis B, didn't it?
Again, I think if you're referring to the table,
I am.
That's the case, yes.
Yeah,
I think it is,
yeah.
yes, it's in the table.
And on the 2nd of September, we can take that down, thank you, you told Parliament, and you've already referred to it, the government was accepting 69 of the 74 recommendations, and this was one of the 69 that you were accepting. Is that right?
Yes.
So it's absolutely clear that, as a response to engagement from the infected and affected, both Sir Robert Francis and the expert group advised, and you decided, that the scheme would include the SCM or equivalent.
Yes, that there was going to be a supplementary health route. That is absolutely true. Where, if I just to pick up the point here, because I think what also happened here is that there were certain conditions that meant that people were on the special category mechanism in the support schemes that were already taken into account in the core route. So an example of that would be something like chronic fatigue, for example, which clearly would affect people's ability to work. So that was something that was taken into account in the core route. So that's why there isn't that perfect crossover in the scheme between special category mechanism conditions into the supplemental health route.
Well, let's get the point in time right, because this chronological development is important. As at the 2nd of September, you published something which said that in the scheme there would be criteria that were the same as the SCM and equivalent schemes.
That's exactly what's mentioned.
We then get to January of this year. If we could look, please, at a fact sheet produced by the Cabinet Office in January, WITN 6392300. And if we could go to pages, I think it's 6 to 7 of the internal pagination. Next page. Oh no, it is that page. Thank you, Lawrence. Could we zoom in on the bottom half of the page? Thank you. So, what we see here, and I'm going to suggest to you it's not as clearly set out as it could be, is now something called the Severe Health Condition Award. It's said it's going to be eligible to people who've suffered from a specified rare severe health condition, and we've seen the examples, those that are listed in the regulations. It's asserted that this has been developed following advice from the expert group, and then in the last part of that second paragraph, the scheme will therefore have different thresholds and eligibility requirements to the infected blood support schemes for the Severe Health Condition Awards. And then the next paragraph says, the eligibility criteria won't change the value of support schemes that a beneficiary will continue to receive as part of their compensation package if that is the option they choose. That means IBSS beneficiaries will continue to receive the SCM without providing further evidence, but all applicants will need to show IBCA that they have one of the qualifying listed health conditions to be eligible for the Severe Health Condition Award through the scheme's own supplementary route. Now, this, I'm going to suggest to you, Minister, is the first indication that the government's position, as previously determined in August and communicated by you to Parliament through saying that the recommendations had been accepted, had changed. That's right, isn't it?
With one qualifier to that, which is that in the government document, which I think is the 23rd of August, it did set out that there would be evidence requirements for the qualification for the supplemental health award. And that is because that supplementary award, the Severe Health Condition Award, although of course it would refer to people who were already receiving money under the special category mechanism, it would also encompass people, for example, Hep B sufferers who wouldn't be on the IBSS scheme, but who still would have a way of qualifying for a Severe Health Condition Award. So there is that point made about the requirement of the evidence that is in the 23rd of August document, but in terms of that level of clarity, yes.
Well, it's a wholesale change of position, isn't it? Which means that anyone not registered with the support schemes, and that will include obviously people infected with hepatitis B, it will include those infected after the 1st of September 1991, it may include people who are newly discovering that they were infected, and we know that those people are being identified. It means that they are not eligible to receive anything in terms of the special category mechanism or equivalent. That's right, isn't it?
Yes, yes. And just to pick up this point, though, with regard to the supplemental route, and that is what was added to that scheme in the summer. The government document of the 23rd of August did actually set out, as I say, there would be evidential requirements. What it didn't explicitly say, and I accept, is that there would not be an automatic crossover. So in terms of your point about clarity, I do accept that.
Well, Minister, forgive me. It's not that what was set out in August didn't make clear what is now the position. It's that what is set out in August is fundamentally different from what is now the position.
And the difference is that there were conditions under the special category mechanism that are accounted for in the core route. So I'm just explaining the difference, and that is, I gave the example of someone with chronic fatigue, for example. That would be taken into account in the core route, and that is the reason behind that. But I accept entirely your point about the clarity of the communication.
But if that's right, why did the expert group and Sir Robert recommend what they recommended in August of last year, and why did you accept it?
Well, obviously you have to ask them the reason for why they recommended things. What has happened, though, is that there has been that look at the scheme, at what is included in the core route and what is included in the supplemental route, which is what has happened.
The effect of this, as well as excluding those who are not registered and in receipt of SCM or equivalent currently, is that those who are registered, whilst they can continue to receive those payments, they are forced effectively to go down the regular payment route and not the lump sum route. The lump sum route's been closed off to them.
In terms, first of all, I think that they can obviously continue with the support schemes because that's a change that's been made to the scheme last summer.
I want to look at one further document on this issue, which is the document which seems to have been the basis for the government's decision. It's the 12th of February addendum report from the expert group, WITN 7762015. And if we could go to the bottom of page 4. Next page. So you'll see the bottom of that page, Severe Health Condition Awards, and if we can go over to the next page, you'll see what... no, sorry. Can we go... Thank you. Can we just go back to the previous page? My apologies. I think I've got the wrong reference.
There is the bit about conditions being taken into account.
Yeah,
in the
no,
core.
it's... let's go, sorry, page 15. So we see here, it said the expert group has reviewed the criteria used in existing infected blood support schemes for enhanced, advanced or special category payments. Just pausing there is reference, I think, in the earlier part, in the page I can't locate, to the government having invited the expert group expressly to provide further detailed advice on this issue. Is that correct?
I don't recall it specifically, but yes.
So having been asked by the government to look at it again, we see that the expert group does so. And then it says this: the expert groups identified the following additional hepatitis-associated disorders that can result in long-term severe disability. And that's the list of very rare conditions that now appear in the regulations. And then this: as the compensation scheme is based on clinical markers that will be accessible, assessable and verifiable, the group does not think it appropriate or proportionate to require applicants to make personal life impact statements. So pausing there, one of the bases, if not the basis, for the group's volte-face, its reversal of its previous advice, appears to be that it doesn't think applicants should be required to describe the impact of their condition on them, and it's reached that view without asking a single applicant what they think about that proposition. That's right, isn't it?
As far as I'm aware, yes.
Yeah. Why?
Well, again, you'd have to ask the group why that.
Well, no,
is the
forgive
case,
me,
but
Minister. I'm not going to ask the group. We're not calling the group. You've commissioned and you've accepted this advice.
Yes, I appreciate that, but I can read the advice on the page. What I can't comment on is particular, motivation, as I'm sure you'll understand. But, the point here is that the broad point is around the clinical markers point, and that is because there are obviously the group of victims who are receiving money under the special category mechanism, but there's also another group of victims who wouldn't have been part of the support schemes, but who would also qualify for this. So my recollection of this is that the clinical markers point was for fairness across both those groups and for the integrity of the scheme.
Well, surely those who didn't currently receive the STM or equivalent, but who might well want to because for the first time they're allowed to be registered with the scheme, fairness is ensured by giving them the same opportunity that those already registered with the schemes have had.
But the point being here that there is the clinical markers is a single qualifier across both groups. That's how I read that.
Were you aware that the SCM and its equivalents had been very hard fought for by the community?
It was, yes.
And they had greatly valued it. And one of the reasons they valued it is for the very reason the expert group disparages. It's because they were able to say for the first time to somebody in authority, let me tell you how this disease takes its toll on my life. In Scotland and I think in Wales, there was a process of self-assessment, which, as Sir Robert Francis has previously told this inquiry, was successful. It did not result in fraudulent claims. So the decision that's been taken takes away one of the few successful and welcomed features of the previous schemes. Again, why?
Well, I didn't read that as disparaging on the printed page, but certainly your point about the great battle that so many people went through on the special category mechanism, I absolutely recognise. But the logic behind it, as I say, is to have that single qualifying standard of clinical markers across those registered and those not. That is the purpose behind it. But in terms of the battle people went through for that recognition, I agree 100%.
The group goes on to say in this report, or to suggest, that people won't be disadvantaged by the approach. Now that's not true, is it? Because people cannot go the lump sum route without relinquishing those payments. And it's obviously not true for people who are currently not yet registered with the schemes.
I understand it's precisely the point you're making. I read that sentence in the context of fairness across the two groups, but to I understand the broader point that you're saying.
Given that the government has and the group has done a U-turn and taken back that which was given in the summer and autumn of last year expressly in response to feedback from the infected and affected. And given that you must know, Minister, that this is a topic which has caused enormous anxiety, anger, distress and incomprehension, you've said in your statement you place value on listening to the concerns of the community. You told Parliament on the 2nd of September that the infected and affected have gone unheard for far too long, which has compounded the trauma. Surely, this is one issue, if nothing else, that the government should reconsider urgently.
I hear entirely what you're saying, and I say to the inquiry today, as I have on other issues that have been put to me today, that I am more than willing to go back and look at precisely that.
Thank you. I think I've got about 10 minutes, but I think I'm looking for anyone who can tell me the position of the stenographers. it okay to continue? It is, great. Unethical Research Awards. First of all, you will know that for those who do qualify, many regard the sum as insultingly low. And the inquiry heard this morning from Gary, on behalf of himself and other Trelaws survivors, who regard it as disgraceful and an insult. Do you have any comments on that?
Well, on this, firstly, let there be no doubt as to the unethical research that victims are subject to is a disgrace and an absolute stain on our country, frankly. So let there be no doubt or ambiguity about that. In terms of the amounts, what I accepted from Sir Robert Francis were obviously not those figures in isolation with nothing else. What I accepted were recommendations about an uplift to the Autonomy Award. So say, for example, take the midpoint of around £50,000 on the Autonomy Award. I stand to be correct on the figures, but that's the figure I have in my head. Clearly, the 10,000 in respect of the unethical research that isn't Trelaws would be an uplift to that. The 15,000 would then be an uplift to that if it's in relation to someone who was at Trelaws. Now, I accepted those uplifts as they were put to me and they were recommended to me. What I didn't do was, and I don't think it would be wise, proportionate or reasonable for me to start inserting arbitrary figures instead, but I certainly accepted them as an uplift to the Autonomy Award in the very awful circumstances that people find themselves in.
And you will understand, I know, Minister, that arbitrary is exactly what people think of it, arbitrary and tokenistic.
Of course, I understand.
And that is another matter which I know those sitting here will urge you to go away and reflect on. The other aspect of the Unethical Research Awards is that the regulations identify which centres they apply to and also those who are subject to the Dr. John Krask's research. Now, my understanding of your position, and I think it's also set out in a parliamentary written answer at some point over the last few weeks, is that the government is able, through further secondary legislation, to add additional centres or studies to the list if new evidence is presented.
That's correct.
And I flag this in particular because we know that there are those here who do not understand that the non-inclusion of Belfast, of the associate centres associated with Cardiff, of Alderhay, of Birmingham Children's, and so on. However, it does seem a big ask for people to have to persuade government to legislate when the scheme could create a power within IBCA to consider evidence on an individual basis. And we know of one example, but this is just one example of what we know happen more widely. It's someone who's referred to in the written presentation, you will have their details, of someone essentially treated experimentally as a pup or virgin haemophiliac, to use that dreadful phrase. Yeah. If that person has evidence that they were subjected to something which falls within the parameters of this award, wouldn't it be an awful lot quicker, bearing in mind that's your yardstick, you've told us, if they could go to IBCA and say, look at my records, look at what this doctor said or did, grant me that award.
Again, I am more than happy to look at that. The yardstick I use is, does that cause undue delay in the generality of the scheme? Is there any reason why this, for those who do fall within the existing scheme, why that can't simply be paid as part of the core award? If someone doesn't have any further supplementary award and the only part of the supplementary award route they're entitled to is this, it would be an awful lot easier, wouldn't it? And quicker for that to be paid. Again, speed is always the criterion I use to judge. Legal support. Your statement, paragraphs 78 through to 81, suggested this.
He said, the scheme is tariff-based. This means individuals do not need to provide a detailed account of losses. Therefore, it's not expected that an individual would require legal support to apply. However, I will continue to endorse the provision of support to applicants to the scheme where it's appropriate and in line with proper use of public funds.
Yes.
Now, you're a barrister. I'm a barrister. I've read the regulations several times. There are parts of it that I find frankly incomprehensible, that would take me days to sit down and work through. It's not realistic or fair, is it, that any individual should be without legal support in the appropriate degree of preparation of and advice in relation to their claim, if they want it.
And that is why I have signed off both legal support and also financial advice as well. And that's what I had in mind. And again, I just highlight, again, the balance that there is to be struck here, because clearly the purpose of having a broad-based tariff scheme to which victims can go means that you do not have the thousands of civil claims before our courts. That's what the idea is behind having a broad-based tariff scheme. But the second thing that I also have in my mind, and before I say this, this is not a comment in any sense on the lawyers who are working extremely hard supporting victims here, but I also have in my mind experience of previous government compensation schemes. I guess an example would be the miners' compensation scheme, when the debate many years later was not about the money the victims received, but the amount of money that lawyers received. And that's not a comment I hasten to add on the lawyers that are working very hard here. It really isn't. It's just a general point about learning from previous compensation schemes. Absolutely agree on the access to legal advice. It's why I've signed off the support that I have. But the balance to be struck is not to have a situation in times in the future where people actually look back on what the lawyers made from the scheme, not the victims, which is where the money is meant to go.
Funding for the charitable organisations, recommendation 10
Yes.
in the inquiry's report, in the government's December 2024 response to that recommendation, it was to say that scoping work was underway. By spring there'd be a clearer picture. You will have read of the appalling toll on
Yes.
both the organisations like the Hepatitis C Trust and the Haemophilia Society,
Yes.
but also on organisations such as Haemophilia Northern Ireland, Haemophilia Wales, and a number of the other groups that are providing invaluable and necessary support to people during this time. I don't want to be unduly cynical, but it was last Friday that the Department of Health finally made an offer to the Haemophilia Society, Hepatitis C Trust and Thalassemia Society. It's difficult to avoid the inference that that is action that has been accelerated, shall we say, by the fact that there's a minister appearing before the inquiry
Well,
today.
just to say, I make no apology at all for using, there were two imminent deadlines here. One was, yes, absolutely, this inquiry. The second is obviously that with, and I'm just hesitating to commit Sir Brian to next week because I need the permission of the House of Commons Speaker, but I would obviously hope to make a statement to Parliament in the very near future on progress on Sir Brian's recommendations for last year. So I make no apology at all for using those deadlines to drive the system. But what I would say as well is that there have been two public health ministers in this period. I wrote, and it was in the meeting that I had back in December with victims, to the Department for Health, urging progress on this matter. There was then a change due to circumstance I don't need to go into before this inquiry. The public health minister resigns and there's a replacement. I obviously gave a small period for that minister to get up to speed, but then was immediately again pressing for this announcement to be made. I understand there was an introductory meeting with Department for Health and Social Care officials and the charities some weeks ago now. The money, I haven't got the letter in front of me, but I think it's over £500,000.
It's £500,000.
Yeah, £500,000 from memory within a DHSC budget. There was, I think, meant to be some additional meetings. I think it was this week, may even have been yesterday, and then there'll be that grant bid to action, so for charities able to bid into that money. But to go back to the original principle, you are absolutely right. There's been extraordinary efforts by charities, patient advocates over decades in this space, providing remarkable support to victims, and also quite extraordinary advocacy as well. But just to be absolutely clear, I've been pushing for months for that money.
Just before I ask you a short number of final roundup, perhaps reflective questions, just while we're on the inquiry's recommendations, and it may be that you will be addressing this when you give your updates to Parliament, in which case please say so. But one of the recommendations was that there be a formal parliamentary mechanism for Parliament to review progress towards the implementation of the recommendations of public inquiries. And this inquiry suggested that a particular parliamentary committee might be the right one. Are you able to either give us any update or, if not, answer this question? Will this government commit to providing at least the opportunity for Parliament to express a view and, if appropriate, take action on this issue?
So there's just to distinguish 2 points here. It's obviously a matter for Parliament if Parliament wants one of its select committees that exists to monitor the implementation or otherwise of recommendations by public inquiry. So it's a matter for Parliament. In terms of the government's position, the government is looking at wider inquiries reform. One of the things I've been doing is to actually get publicly onto the government website, looking at public inquiries as to what the position is in terms of implementation of the recommendations. And I also, just in the interest of transparency, the government is also looking more widely at public inquiries, how they proceed, how they can best obviously fulfill the really important, crucial role they have in our society of getting to truth, but also providing justice for victims, but also delivering recommendations that can be implemented in a timely manner as well. So that is a broader piece of work that is currently ongoing.
Then just a handful of final questions before we break, and I invite questions from core participants. On the 20th of May of last year, the then Prime Minister gave what he described as a solemn promise to pay comprehensive compensation to those infected and those affected by this scandal, accepting the principles recommended by the inquiry, which builds on the work of Sir Robert Francis. Whatever it costs to deliver the scheme, we will pay it. Of course, 2 days later, he called a general election. But leaving that aside, does that also reflect the position of this government?
Yes.
Secondly, I know you weren't able to be here for this morning's evidence. Can I invite you, and I know how busy you must be, but can I invite you, on behalf of everyone here and on behalf of the panel who gave evidence, not just to read the transcript of that evidence, but to watch the full morning's evidence, because you will see and hear the issues there raised. And can I invite you not just to watch and listen, but, to quote from the panel participants, to hear. In other words, to give serious consideration to all the points that have been made by our panel this morning.
Yes.
So I think that's probably the ideal moment for me to say my question's largely done, but I now need to give the opportunity to others to put forward further questions. And can I ask for 20 minutes for that?
Do you have any idea from any such information as you may have received remotely how long you might need?
Sir, I'm good, but I can't work out what emails I've had in the course of the afternoon. So I've no idea, but based upon previous experience, can I have 20 minutes?
Right. That's very impressive. If you can do it, If we need more time, you will simply ask and we'll tell you, but you can be sure, Minister, that Mr. Richards will work at pace.